What is this policy? Who does this impact? We're going to do an end-to-end analysis of this public policy. We're going to dissect it, and we're going to go over all the details. In today's world, whenever a new policy is announced, there's a lot of different interpretations, and it's important that you understand your situation and if it applies to you. Otherwise, you may end up doing something that will violate the act, violate the law, and can bite you back in the future. IRCC released a public policy on May the 28th, exempting certain foreign workers from certain requirements when changing their employment, especially for the folks who were on closed work permit. And this is a very big announcement, a big relief for folks who had to wait long processing times while awaiting new closed work permit. What is this policy? Who does this impact? We're going to do an end-to-end analysis of this public policy. We're going to dissect it, and we're going to go over all the details. So stay tuned until the end of this video. Welcome back to the channel, guys. My name is Roop. I'm a regulated Canadian immigration consultant. At our firm FHCN, we assist all prospective immigrants with their immigration to Canada. If you are an aspirant, you need assistance, here is our contact information. Feel free to contact us and we would be happy to assist you. If you would like to speak to me or any other RCIC in our firm, you can feel free to book a meeting. The link to book an appointment is in the description of this video. Now, before we go into the details of this public policy, let's quickly answer the comment of the week. And the comment of the week is on our video on can I work while my PGWP is in process? And the question is, can I work in any province in Canada while awaiting my PGWP? That's an excellent question, very practical question, and the answer is yes, you can work anywhere in Canada while you await your postgraduate work permit. I hope this helps. Now, coming back to the temporary public policy that was announced by IRCC on May 28, 2025. Here on the screen, you can see the temporary public policy to exempt foreign nationals in Canada from certain requirements when changing employment. Now, this is basically background why this policy is necessary, what is the IRCC trying to accomplish. And overall, basically what they're saying is there may, however, arise situations beyond either the workers or the employer's control where continuing the employment contract is no longer possible. Right? This could include, but is not limited to, situations such as taking on a new role with the same employer, layoffs, conflict or incompatibility within the workplace, and seeking a better compensation package or professional growth opportunity with a different employer that leads the worker to have to obtain a new work permit. Now, guys, this particular policy is for folks who are on closed work permit, who are on restricted work permits, and IRCC says that oftentimes folks have to apply for a new work permit. And if, say, you are on a restricted work permit, you're on a closed work permit, you can only work for that employer. You can only work for that employer, and more often it is tied to an occupation. Now, if you got a promotion, or you had to leave that job, or you got a better salary elsewhere, or you are in a situation, unfortunately, being laid off, or you had to leave that job because of harassment, you have to find a new employer, you have to get a new LMIA, that's fine. And then you have to wait for IRCC to process your work permit to give you the final work permit approval. And only then you can start working with the new employer. Now, in this case, guys, if you are in a position where IRCC ends up taking 4 or 5 months to process your new LMIA based work permit, new closed work permit takes 4 to 5 months, and you, in this particular duration, previously you couldn't have done anything else. You either have to continue working with the old employer, or you have to, if that's not an option, then you can't do anything else. You have to sit idle while you await the new work permit. This policy changes that. Now, if we look at the consideration, it says aligned with government goals to reduce the inflow of new temporary workers to Canada. It is important to better utilize the skills and training of the workers that are already in Canada. And to do that, they are referring to a timely transition to new employment is beneficial to both employers and workers, where employers are able to hire workers and workers can start working quickly. So what is this policy all about? Let me give you the TLDR. Basically, if you are on a closed work permit and you have applied for another closed work permit, now while you await a decision on that new closed work permit, you can start working with the new employer. You don't have to wait for the application to be approved. That is the gist of this policy. Now, how it works and in what cases it works, let's go over this. Now, individuals that are expected to benefit who are on maintained status and are authorized to work while their work permit application is pending, but who are bound to the conditions imposed on their expired work permit such that they cannot move to a new occupation. So, in other words, you had a closed work permit, you applied for an extension, but uh, because you were on closed work permit under the implied status rules, you have to follow the same conditions of your previous work permit, and hence you cannot work for a new employer. For individuals, foreign nationals who continue to hold a valid work permit that limits them to working for a named employer but need to transition to a different occupation or employer for reasons that may have been including layoff. Folks that who are work permit exempt but require a work permit to work in a new occupation. So assuming in this case you had the authorization or you have the authorization to work and you've applied for a new work permit, which is a closed work permit. The previous authorization to work restricts you to a specific employer, and now you've applied for a new work permit with a new employer. However, you are still kind of in the waiting period. That's where this policy hits, and that's where the policy says that, you know what, you can start working. So let's talk about the conditions with regards to the eligibility. So here on the screen, you can see that based on this public policy, officers may grant an exemption from the requirements of the regulation identified if the foreign national satisfies that the person is in Canada with valid temporary residence status. So you need to have a valid status. If you don't, then none of this applies. If you are in restoration, if you've lost your status, then none of this applies. Don't bother reading this policy any further. Second is meets the requirement of paragraph 199A and 199B or the 199B of the regulation. So let me show you what this particular regulation is. So over here you can see the 199A and 199B. Either you hold a work permit or you are working in Canada under authority of section 186. So 186 is your implied status. So either you are in Canada on a valid status, valid work permit, or you are under maintained status because you have applied for some sort of work permit extension. Have submitted a work permit renewal application under section 201. So basically this point here says that you have submitted an application for which you are eligible, for which you for a job that you had received, you are eligible to do that job, and hence you have submitted that application, or you have submitted a new work permit application to do a job or to perform work described in paragraph 200 section 1 subsection C subsection 2.1 or 201C3 of the regulation, and the application is still under process, intends to work for a new employer and or occupation specified to the job offer included in their work permit application. So now you were working for some other employer before, you were a closed work permit, now you want to work for a new employer and you have applied for a work permit for that employer. Has applied for the public policy exemption using electronic means identified by the department for the purpose or with an alternate format. Now guys, this is yet to be discovered. Essentially there will be a process by which you can notify the department that you are applying under this public policy and then has requested exemption to be applicable until a decision is made. So you need to make that request. So this is the entire gist of this policy. Overall, in short, in summary, if you are a closed work permit holder, you are looking to change employment and you're applying for another closed work permit, you don't have to wait for the new work permit to approve. You can change employer. Or you are a work permit, closed work permit holder, the work permit that you had expired already, but you before the expiry you had applied for a new work permit with a new employer. Now you can start working for that new employer without waiting for the work permit to get approved. These are the main areas where this policy applies. For all those folks who don't fall in this, please don't start working, as your work may be unauthorized. And if you need clarification, you can always contact us. We'd be happy to assist you. In today's world, whenever a new policy is announced, there's a lot of different interpretations, and it's important that you understand your situation and if it applies to you. Otherwise, you may end up doing something that will violate the act, violate the law, and can bite you back in the future. That's it for this video, guys. We have covered this new policy. If you like this video, please hit the like button, subscribe to the channel, and hit the bell icon so you are notified about any new video that we upload. Thanks a lot for watching, guys, and I'll see you in the next video.